striking rules is Unit 3, Question 2. And before we go, we have some of my graduate faces. Do some, you already know who I am, so.
You guys know who I am.
Okay, all right.
And I'm Brandon Price. I work at the AG's office.
And he was in Mr. Mack and Mr. Oaks' class at Reed like a million years ago.
Wonderful.
It's awesome. No, Brandon's a long time.
I love it.
Yeah, so I was in the We the People program, which is like.
Alrighty.
Yeah,
So,
yeah.
Unit 3, Question 2. Justice Oliver Wendell Holmes said that this. Oh wait, introduce yourselves.
Yes. Hello, we are Unit 3 from Reno, Nevada. Do I say Reno, Nevada?
Reno High School.
Reno High School? Okay,
And I
okay.
think you'd probably be okay with that, so
Okay.
figure it out.
Okay. Hello, we are Unit 3 from Reno High School. Our unit coach is Mr. Matthew Oaks, and our teacher is Mr. Richard Clark. My name is Bailey Parkin, and I'm attending the University of Nevada, Reno next year.
My name is Jacqueline Nooner, and I am attending the University of Nevada, Reno next year.
My name is Annika Jensen, and I'll be attending Smith College next year.
My name is Carson Wagner, and I'll be attending University of Nevada, Reno.
My name is Maddie Smith. I'll be attending Portland State.
Alright, Unit 3, Question 2. Justice Oliver Wendell Holmes said that the Supreme Court's power to review state laws was substantially more important to the Union than its power to review acts of Congress. Do you agree or disagree? Why? What evidence can you offer to support your response? How important is the U.S. Supreme Court's power to review executive orders? Why has judicial review continued to be controversial? You may begin.
Publius articulated in Federalist 78, the interpretation of the laws is the proper and peculiar province of the courts. The principle of judicial review, illustrated by Alexander Hamilton, was not a new idea in 1788, and it was not a revolutionary landmark decision in the 1803 case Marbury v. Madison. Judicial review began with the philosopher kings in ancient Greece, and was indoctrinated into British common law with Dr. Bonham's case in 1610 by stating that the decisions made by judges were superior to the legislation of English Parliament. Through British common law, the tradition of judicial review carried into colonial American customs. From the 1792 case Chisholm v. Georgia to the 1810 case Fletcher v. Penn, the Supreme Court has used judicial review to strike down several state laws. However, the 1833 case of Barron v. Baltimore ruled that the Bill of Rights only applied to the national government and brought the use of judicial review regarding states to a halt.
The reluctance of the court to address controversial state issues ultimately leads to the Dred Scott decision and the Civil War, leading to profound changes to the Constitution in the form of the 13th, 14th, and 15th Amendments. John Bingham authored the 14th Amendment to overturn both Barron and Dred Scott in order to allow the courts to once again review state laws. Justice Oliver Wendell Holmes highlighted Bingham's ideals of incorporation, stating that the court's power to review state laws was substantially more important to the Union than its power to review acts of Congress. In the 1925 case, Gitlow v. New York, the court reaffirmed that state laws themselves can be challenged, allowing for the expansion of federal jurisdiction, upholding the idea of double security. The Supreme Court has only overturned about 150 congressional acts, but over 1,200 state laws, mostly throughout the 20th century, in efforts to expand and protect civil liberties. Although acts of Congress share the same potential as state laws to create dangerous legislation, Congress itself is comprised of elected officials from each state, making it a more representative and democratic body. State actions, though made by officials elected by state residents thereof, can set dangerous precedent for other state and circuit court of appeals decisions.
In addition to the Supreme Court's power to review state laws, the ability to review executive orders is of equal or greater magnitude. Because the President is elected by the majority of the Electoral College and is empowered by both the vesting clause and the faithful execution clause in Article 2, the executive is the only branch able to direct legislation when faced with congressional gridlock. From George Washington's presidency until today, presidents have used their power to order the execution of laws as they see fit.
In the majority opinion for the 1952 case Youngstown v. Sawyer, Justice Hugo Black wrote, "The President's power, if any, is to issue the order must stem from an act of Congress or the Constitution itself." Justice Robert Jackson's concurring opinion lays out the executive traffic light, establishing how far the reach of the executive arm is allowed to stretch. President Barack Obama has faced much scrutiny over his executive orders on immigration, and most recently his memorandums attempting to uphold prior legislation on gun control. On April 18th, the court will hear the oral arguments for the case U.S. v. Texas regarding President Obama's expansions of DACA and DAPA, the first step in the court's reviewing how far an executive action can stem from an act of Congress.
The Supreme Court plays a crucial but paradoxical role in America's democracy. It is the court's distinct burden to review executive actions, along with congressional and state acts, in order to ensure contestations within each area of government revolve around their constitutionality. Judicial review is not controversial itself, yet Justice Anthony Kennedy acknowledges the fears of many that a democracy should not be dependent for its major decisions on what 9 unelected people from a narrow legal background have to say. Since February, the seat at the right hand of Justice Roberts has been shrouded in black. The death of Antonin Scalia has highlighted this controversy of resting the fate of a nation in such a volatile and imperative branch. The nomination of Chief Judge Merrick Garland has granted both the Senate and the President a unique opportunity to shape the future of the Constitution. As we have seen in landmark cases such as McCulloch v. Maryland, Dred Scott, Gideon v. Wainwright, Citizens United, and Obergefell v. Hodges, the consequences of judicial review will long outlast any temporary controversy it inspires. Thank you.
440. Considering you guys were like at 900 minutes before, I think.
Yeah,
Not too bad.
it's a step up.
It is a step up. I have a few minutes of cross-hatch for you. Can the Supreme Court or any federal court invalidate a provision of a state constitution because it violates a federal statute?
I would argue yes, the Supreme Court does have the power to review certain areas that are mentioned in the state constitution if they conflict with federal statute. The federal law is the blanket that covers the entire nation. So although states are allowed to have different versions of different types of penalties or different types of legal action that happens if a citizen commits a crime, if a federal statute has created precedent for an overwhelming arch of what that actual punishment should be, all state legislation should be replaced with the federal statute that's been agreed upon by the Supreme Court.
What powers besides executive orders has the court used with judicial review to check the power of the president?
Well, as we said in U.S. v. Texas, the Supreme Court is checking the power of the president. When Obama did the executive order about the Second Amendment, the Supreme Court is checking his executive order through judicial review in the case U.S. v. Texas.
But other than just simply checking his executive orders, they're able to check the president's power through other means, especially when they evaluate different types of voting methods. Actually, just released today was the decision in Evansville v. Abbott, which decided that districting of different congressional districts would be based on total population permanently, not on total voter population. And this decision was reached unanimously by the current contested Supreme Court, if you will. So it shows that even in times of severe stress, important issues can still be agreed upon. And this is one way they can check the president's power, because if a president prefers certain districts to lean certain ways in order to influence their party's standing in Washington, the court is able to check that by ensuring that democracy prevails on a local level.
If we have a 4-4 tie for all intents and purposes in the Supreme Court, tie goes to the runner. Basically, whoever, whichever side won at the circuit court level wins. Doesn't that effectively render the circuit court judges de facto Supreme Court justices? And is that a proper role for a Ninth Circuit or Third Circuit judge to decide law for the entire country?
Not necessarily. A circuit judge is only a circuit judge, and so we have the Supreme Court specifically to make sure that this problem is resolved at a national level. They're a national branch of our government, so therefore it's not up to a circuit judge to decide national standing.
In addition to Maddie's point, the idea that the circuit decision stands will only apply to the circuit in which they reside. So although it could create persuasive authority for other districts to follow suit, there is no legal action that guarantees that all other circuits will follow the decision that was made there. Later in the future, when the court becomes more stable, the Supreme Court that is, different circuits could bring this same sort of, well, when it returns to a 9-person body, different circuits will be able to bring the same issues back to light and sort of resurface the argument and have it face a more full body of the court.
I just forgot where I was gonna go with it. Let's see.
That whole thing, it was awesome.
District court judges, they have they may not have as much experience as the Supreme Court, but they do have experience in legislating. And so even though the decision that was made may have been wrong to one side of the party, if the decision goes to the Supreme Court and it's tied 4-4 and has to go back down to the runner-up, it might have actually just been the best decision that they could have made.
How has the Supreme Court's power of judicial review expanded the power of the court, and does the Supreme Court have too much power with judicial review?
Well, as you can see with the 14th Amendment, the idea of judicial review was brought down to the state level. Therefore, the Supreme Court can now review state laws and either decide if they were right or wrong. And this was a big step having to do with judicial review. As we can see in Barron v. Baltimore, prior to the 14th Amendment, the Supreme Court found that they did not have the power to be able to strike down state laws. So I think that's an important part that they have today.
Many people have a problem with judicial review because they see it as overstepping their bounds and interfering into states' rights, and that becomes a controversy. We can see in cases like Reed v. Arizona how the Supreme Court coming down into a state level makes some people fear that they have overstepped their power and that they are now an uncontrollable branch of government because they have life tenure and there's no way to get them out if they make a decision that a state or the public may not agree with.
As James Madison articulated in Federalist 10, there is a very strong reason to fear factions. Factions can create a lot of discord, and especially if a certain group of people can get together and pass legislation in the form of a state body, that could create a dangerous precedent. So no, by no means does the Supreme Court reach too far with judicial review. Judicial review itself has to be based in constitutional thought and various legal scholarship. So any decision that they could reach from judicial review has to be backed up. So no, it does not stem too far and does check these dangerous factions that we will warn.